of the research that I've been doing over the last, 5 years or so, and then focus on a particular aspect of it. And I've been intrigued for some time by what difference it makes, if any, who the decision maker is in a legal case. And so most typically you think of a judge in a court case. Because I also teach ADR, my research has also moved to what difference does it make who the arbitrator is. So I've studied both judges and arbitrators, but I'll start with judges for the moment. And the question is, can be thought of in an intuitive way, and then a kind of theoretical way, and then a kind of empirical way. All right, so if one thinks about, does it make a difference who the judge is? I think our intuitive sense would be, well, yes, right? Because the judge is a human person, and the way they deal with the facts and the law might differ depending on that humanness, right? On a theoretical sense, and there are lots of different ways to approach this, but maybe put in a very simple way, from a theoretical sense, there is this debate between formalists and realists. And so what the formalist would say is, well, actually it shouldn't make a difference who the particular judge is, because from a formalist sense, the law is pretty predictable. You know, we have all of these pretty predictable legal principles, and we have legal precedent. And not only that, but judges have professional socialization. Right, so they know what they're supposed to do. They're supposed to be neutral. They're supposed to really just look at the legal principles. They wouldn't let any of their humanness filter in, you know, because that's just not what they're supposed to do, and they don't have to because there's the legal principles and the legal precedents, etc. So that's, on the other hand, on sort of the theory side, there's what sometimes people call the realist. And the realist would say, well, now they're still human beings, and when they walk in that courtroom door, they don't put away their humanness, right? They don't put away their gender, they don't put away their race, they don't put away whatever demographic information they may have. They don't just put that away. So that's sort of, so from a theoretical standpoint, the formalist would answer in one way and the realist might answer in the other. Well, I was interested in what the empirical answer would be. And by empirical, I mean if we studied it by looking at observable information, what difference would it make who a judge is? And for a variety of reasons, I started studying the judge's race and then the judge's gender. And for a variety of reasons, I specifically studied harassment cases, workplace harassment cases. And so I've studied racial harassment cases and sexual harassment cases and sex discrimination cases. All right. So my questions started to become more narrow over time. And in part that was because of my own interest, but also in part because of the necessity of empirical research to start to refine exactly what your research agenda is and the research data that you need to focus on, etc. So I started to study the subject initially of, does the judge's race make a difference in racial harassment cases? All right? So that was my initial inquiry some years back, actually, like I said, maybe about 5 years back. I work with social scientists. I learned a bit about statistics, et cetera, et cetera. And I focused on federal cases in racial harassment. Right? I did an extensive review of cases over a decade. And what I found, well, let me ask you, what do you think I found? Does the judge's race make a difference in racial harassment cases? And maybe I should take a step back and just say something about these cases. So, however, this is not like a trick exercise like Professor Villano had for us. This is not a trick exercise. But so I asked a question. I didn't let you answer it because I want to give you a little more background. So harassment. Harassment under Title VII, harassment as it's been developed under employment law, workplace law, employment discrimination law, has a number of elements before you can substantiate that the plaintiff has proven a harassment case. But the most litigated issues consistently are these two, which is, and I'll use the context of race for the moment, although in due course I'll be focusing on sex or gender. So two key cases in the harassment area is, can you attribute the harassment to that individual's protected category? So in this case, race. So let's say, hypothetically, in a case, that a worker, let's say an Asian woman, said that she was racially harassed. And she's claiming she was racially harassed because she was Asian, right? She has to prove that that was the reason she was harassed. Not because she was from Texas, not because she did poor work, not because, any number of things, not because she had an obnoxious voice, whatever. She has to actually identify, she has to attribute the harassment to her protected status. In this case, her race, in this case, Asian, right? So this is an issue that's consistently litigated. The second issue that's consistently litigated is, was that harassment severe or pervasive harassment? I actually have and here, it should be or. But is it severe or pervasive harassment? So again, in my hypothetical case, Asian woman claims that she was harassed because she was Asian, and that harassment was severe and pervasive, so severe and pervasive that her work was debilitated in a way that she ended up being in a hostile work environment. She couldn't function the way she should function in her job, all right? All right, so she would have to prove the severity and pervasiveness of her harassment. Right? And so there's a lot of litigation on what that means as well. And perhaps very critically, one should remember that that lens through which you determine these two things is the reasonable person. So it's not like the courts have fully identified all the factors that are relevant in determining attribution or severity and pervasiveness. They say, what would a reasonable person, how would a reasonable person assess that fact pattern, that situation, and would they conclude that the harassment was because of race and that harassment was severe and pervasive enough? All right, so the reason I emphasize this is to highlight that in this area of the law, there is discretion in decision making. The legal principles are clear, but the interpretation, according to the law, is according to the reasonable person, which you may or may not agree, but it's been my experience, that when the law uses the term reasonableness, it opens the door a crack to interpretation, right? Because you have to always say, whose reasonableness are we discussing? And it suggests that the notion of reasonableness has some fluidity, right? All right. Okay, so that little background, let me ask my question again. Do you think it makes a difference if the judge's race makes a difference in determining whether or not there is racial harassment? Keeping in mind that the judge has to decide if the reason that person was harassed was because of race, and that harassment was severe and pervasive, all right? And that, again, these kinds of, for example, this could be ethnic slurs, this could be, let's see, kind of Asian stereotypes might be, the woman might have been a systems analyst, but in her cubicle, they left a whole pile of chopsticks. I don't know, but it could be a whole range of things, from the use of words to the use of symbols to well, you can see, imagine the kind of being not invited to the lunch that's being given, etc. All right. So, okay, what do you think? Does it make a difference? Yes. You said yes? Yes. Anybody disagree? No. Okay. All right. It seems it depends on the audience whether it seems intuitive or not. But in fact, that's what the empirical evidence showed. It did make a difference. The judge's race made a difference in the outcome of the cases. So it was statistically significant. It doesn't mean that there weren't other variables that were relevant. It certainly doesn't mean that any particular judge of a certain race would reach a particular outcome. But what the evidence suggested is that it did make a difference, and it was more likely for an African American judge to find racial harassment for an African American plaintiff, right? And so that was the outcome that I found. Yes.
How about if it were an African American judge and an Asian plaintiff?
Okay, so I actually did look in a subsequent study at all of the variables and the race of the plaintiff as well as the race of the judge. And in some of the cells, there weren't great numbers. So the highest number was, of course, white judges and black judges and black plaintiffs. So the most likely scenario was white judge, black plaintiff. But there were enough black judges to, I think, meaningfully analyze. So what we found was that black judges as a group tended to be more pro-plaintiff no matter what the race of the plaintiff was. But on some of the other pairs that we looked at, it wasn't always the case. So for instance, Asian judges, which were the smallest number, therefore it's difficult to generalize, tended to be more negative about black plaintiffs, for instance. I don't know why, but anyways. But in answer to your particular question, it did appear that there was some same race pairing that was occurring. Okay, so that's what I found out about race. All right, and I could chat more about race, but actually today I thought I would chat more about gender. Because what I did after looking at the race cases was I started studying, does the gender of a judge make a difference in sex discrimination and sexual harassment cases? Right. So I asked that question. Others actually have done research in this area as well. So I really just, in the race harassment area, people had not done research in it. Well, actually there was some limited research, but they were actually doctoral studies and things like that. But in the gender area, in the sex area, other people, political scientists actually, had done work in this area, so I was just confirming what they had found. And so what do you think? Does it make a difference? Does the judge's gender make a difference in sexual harassment cases? What do you think? Does it? You would say yes. Yes. And the answer is yes. Again, answer is yes, and that is a consistent finding across numerous studies that the gender of a judge makes a difference in sex discrimination and sexual harassment cases, and as one might predict, a female judge is more likely to hold for the plaintiff, who is more likely to be a female. All right? All right. I call that the gender effect. And I haven't, and I could call this the race effect, if you want, that I talked about earlier. Now, there's a caveat, and it's a very important caveat, I think, to point out, which is that the judge's race makes a difference in racial harassment cases, and the judge's gender makes a difference in sexual harassment cases. But we don't know that the judge's race or the judge's gender makes a difference in other types of cases, contract cases, tort cases, all right? We don't know that. In fact, the evidence suggests against it. So, and because it's the gender question that has been studied more, let me now shift gears and I'll continue to elaborate on that. So, what has been empirically shown is that the gender of the judge makes a difference, as I say, in these sexual harassment cases. But inconclusive evidence, and in fact evidence to the contrary, that it makes a difference in the other cases studied. So what does that mean? Well, offer you what I think is a possible explanation, which is that a person's demographic, if you will, a person's gender, if you will, makes a difference when the case and the issues make that characteristic salient. So, it makes a difference in a sexual harassment case because the judge's sex makes a difference. And why do I say it makes a difference? Because it affects his or her perception of what happened, right? And affects how they might interpret the facts. Now, I want to take just a step back because I've also chatted about this contrast, if you will. When we say that a person's identity makes a difference, a person's demographic, generally speaking, don't think race, don't think gender, just generally speaking, we don't have any problem with that, not really. Because we say Justice O'Connor grew up on a farm, on a ranch actually, and she did. And another Supreme Court justice was in naval intelligence, and he was. And another Supreme Court justice had diabetes, and she does. And if they had a case that was dealing with property and ranches, or diabetes and healthcare, or military intelligence, and they had experience in it, I don't think we would have any problem saying, well, of course that judge brings to bear that experience into their decision making. And I don't think we have any problem with that. In fact, we generally speaking think it's a good thing, right? Because it gives them insights to understand the property laws and the healthcare laws, etc. But when we shift and say, does a judge's gender and race make a difference? That becomes a very controversial, sensitive topic. As you may recall, Justice Sotomayor's situation, it becomes a very sensitive topic. And why is that? And I really not sure what the answer to that is, the why is that, except certainly as a country we seem very sensitized to, I'd like to think the positives, but certainly also the risk and negatives of gender and race. All right? Okay. All right, so what have we discovered so far then in our talk is that there is a race effect, there is a gender effect in cases dealing with subjects where race and gender become salient, right? And in this case, in sex discrimination and sexual harassment cases. And of course, there's various explanations for why that is. I offered mine, which is I think the experience helps the female judge appreciate nuances of the fact pattern that a male judge would not appreciate. And I actually have a little more supportive evidence of that other than just the conclusion I just told you, the empirical conclusion. Is those, and this is not my research, but those who have studied how the gender diversity of an appellate panel makes a difference have found the following. So this is, if you imagine, appellate panel, sex discrimination, sexual harassment case, all right? Federal appellate panel. If you increase the gender diversity on that panel, so in other words, you add a woman because, and maybe I should have said this at the outset, only 20% of the federal judiciary are women, all right? So if you add a woman to that panel, it's more likely for that panel to now hold for the female plaintiff. So what does that tell me? Well, lots of ways to interpret that, of course, right? But one thing that might be happening is that the judges are sitting there trying with every good intention to resolve the case accurately and fairly. And the female judge says, you know what? This is the way I see it. I noticed this and this and this. And that by informing her colleagues, the two gentlemen on the panel, of the way she saw the facts and the way she'd interpret them, then she introduces some nuances to the fact pattern that were not that apparent to her male colleagues initially, all right? So I think that's a little bit of supporting evidence for my explanation, which is that the female perspective in certain cases helps us understand the facts and the law in a more nuanced way. And in that sense, I think it's positive. All right? Okay. All right, so gender effect among judges, plaintiff success rate in federal courts is low, but it is improved as these diversity effects occur. So it's very difficult to win a case in the federal courts in this area. All right. So then what did I do? Well, you know, I decided, hey, I study arbitration. I studied arbitration. I know what the gender effect is in the courts. I just wonder if it would make a difference in arbitration. Do we have a gender effect in arbitration? And of course, fortuitously, there's now a database I can access on arbitration. There didn't used to be. Arbitration, as many of you may know, of course, is generally speaking confidential, private, etc. But there are databases now. It was prompted by a California law that required that consumer-related arbitrations be released publicly. And so they don't say the names of the parties, but they do release the arbitration award and the reasoning indicated. And under this law, they decided that when you have a mandatory arbitration agreement in a workplace, in other words, where the employees have to go to arbitration to resolve their dispute, including sexual harassment, sexual discrimination disputes, that is a sort of form of a consumer kind of protection scenario, and therefore it had to be disclosed. So I can access now, you can access now, all of these arbitration cases that are administered by the American Arbitration Association. And they have represented, to me at least, that they are comprehensive. Because they said if they were going to do it, they were just going to do it all the way across the country, and they have released them, and they probably thought, who in heck would ever study them empirically? Only an academic, right, would study them empirically. And so that's what I did. I could identify the gender of the arbitrator. I could identify the sex discrimination and sexual harassment cases. And I could look to see if there was a gender effect in arbitration. In the same way there's a gender effect in the courts. What do you think? Is there a gender effect in arbitration? And do I need to take a step back and explain some of the differences between arbitration? No. Linda says, no, please don't. Well, let me just mention a few, okay? Let me see if I even wrote that down. Okay, oops, nope. Too quick on the button there. I gave you the punchline on the answer. All right. Arbitration, as some of you may know, as I've already said, is private and confidential. Some things you may not be as apparent to some people is that they tend to be final in the sense that they're not reviewable by the courts. Therefore, the case is resolved in the arbitration. Another way of saying that is the arbitrator's decision is not reviewed by anyone. And because the presumption is they are not identifiable, even in this system, because they don't really mention the parties' names, even though they do mention the arbitrator's names, then the presumption is that their decision goes unreviewed, and in that sense, unchecked. All right, so that's one difference versus the courts, right, where there is the appeal procedure, review procedure, and it's public. All right, so that's one characteristic of arbitration, at least the private arbitration. It might be different in labor arbitration or securities arbitration, but in private arbitration, it's final and not reviewable and privately information generally speaking. The other difference is that arbitrators tend to have a lot of discretion in the interpretation. Well, first of all, arbitration is a contractual process between the parties. And yes, sometimes they bring in different institutional norms and they opt for institutional administration. But fundamentally, they are a contractual process. The two parties have agreed contractually to go to arbitration. That is the ideal behind it. That was part of the appeal of it, is that the parties could negotiate the terms of the agreement themselves rather than have the courts involved. What that also means is they frequently do not specify what the guiding principle should be in resolving the case. In court, obviously, we assume it's the legal principles. In arbitration, they do not specify that. And in fact, sometimes they view it as a positive that the dispute might be resolved by something else that they think is more conducive to the party's interests. For instance, industry custom. Right? Or equity, something like that. So they are not bound by legal principles. They are not certainly bound by legal precedent. And therefore, they have more discretion, I would argue, in how to interpret or whether to apply the law at all, and certainly how to interpret the law. So you put together the private nature, the non-reviewability, and the flexibility in interpreting what the decision rules will be in arbitration. And you have quite a contrast to the litigation process. And there's lots of critiques out there about the arbitration process. But this is the basis of some of those critiques. So now I go to the question, was there a gender effect in arbitration? And so...
What's the topic, the nature of the disputes that are being arbitrated?
Sex discrimination, sexual harassment. So again, same type of cases that I studied in the federal courts. So I just exactly took, looking at the gender of the decision maker, in this case the arbitrator, in the same type of cases. Now one could argue, yes, the cases are about sex discrimination, sexual harassment, but one could distinguish the cases in various ways because some ended up in arbitration and some ended up in the courts. But nonetheless, the dispute topic was sex discrimination and sexual harassment. All right, does it make a difference? Does gender make a difference?
Yes.
You would think so. You would think so. That was my hypothesis. I thought this is going to be a really easy, short article. I wonder if anybody's going to publish it because it's so obvious. The answer was no. There is no gender effect. I found no gender effect in arbitration. In other words, male arbitrators and female arbitrators had the same plaintiff success rate, which was very low. It was lower than in the courts. It was about 11%. So only 11% of the employees that go to these arbitrations are successful, as opposed to about 20 to 22 or 3% in the courts. But the important part for our discussion is there was no difference between whether or not it was a female arbitrator or a male arbitrator. So I want to ask why. Well, I've already probably suggested why I think. Which is the nature of the processes differs enough so that, well, it might be at least part of an explanation. If we focus on the decision makers, in other words, judges versus arbitrators, there is some real distinctions between how they're selected. Federal judges, generally speaking, right, we all know, are vetted through a particular process, right? They're nominated, they have to be considered by Congress before they're appointed to be federal judges. Presumably there's some vetting of who they are and et cetera, although we wonder these days exactly how that vetting occurs, but nonetheless, there is some vetting of process, some review of their qualifications, et cetera. And once they're selected, they have lifetime job security, right? Okay, arbitrators. Arbitrators are selected according to the market. And their job security is dependent on the market, right? They're like lawyers, really, in that sense. Somebody has to pick them. The parties have to pick them. So that's the market operating. And the clients have to continue to use them, and there is that job security. So the dynamics are different. And I'd be interested in your perspective on this.
We have the same problem with the securities industry because, if you're the plaintiff's attorney.
Right.
That plaintiff is gonna pick up an arbitrator once, but the firms.
Right. Repeat players,
They're
right?
there all the time.
Exactly.
So if you're an arbitrator, you want that firm to keep coming back to you.
Right. So what seems to happen here, and this is based on some other research I've seen that someone has done on how arbitrators are selected in these kinds of cases that I'm describing, is it's the market at work. It's by networks. So, and what happens is the employers tend to be the repeat players, right? So they have a network of which arbitrators they find acceptable. And any good lawyer, of course, would go with an arbitrator that's not against them. I mean, that makes perfect sense, right? And if given a choice, why not pick an arbitrator that might be able to appreciate their perspective well? So that the decision makers, the arbitrators, are selected quite differently than the judges. The vetting process is different. They have lifetime employment, the judges. They have freedom and expression and discretion, but the arbitrators operate under these market forces in selection and client satisfaction. And one possible explanation why you don't have a gender effect is, first, the women arbitrators who are picked have been pre-selected in the sense that they are surviving in the market, which means they are providing the service of the repeat player customers. And those repeat player customers are not going to select individuals who might identify readily with the employees. And as I say, totally understandable, I think, from a market analysis, why they wouldn't do that. But nonetheless, that's what ends up happening, I would argue. And therefore, the gender effect is eliminated, or at least diluted, because it is a subset of women who if they are inclined toward the perspective of, for instance, that the female judges might have, it would be a bit chilled in the sense that they don't, they want to please their clients, or they're not inclined toward seeing that perspective at all, and therefore there's kind of some pre-screening of who end up being female arbitrators. Now, why does this make a difference? Well, a lot of these disputes are now resolved in arbitration. A lot. And I can explain, if you're interested, in the history of how the Supreme Court and courts have endorsed, really, the use of arbitration in these disputes. So a lot of these disputes are not going to the courts at all and are being resolved in arbitration. And so to the extent one believes that the gender effect in court serves a positive purpose, based on at least my sense of the situation, you don't have that positive effect in arbitration. So 513, guys.
It's really interesting.
So I'm glad to hang around, and I guess for purposes of technical compliance, we should hang around a few more minutes. So any questions? But you can leave. I mean, also leave, but I'll stay here for a few more minutes. Yes. I did not look at race, in part because you know what, there is a great database on federal judges where they have self-identified their race. There is no such similar database for arbitrators. In fact, I'm doing a talk, and I haven't prepared the talk. I'm going to a conference doing a talk on whether the race of arbitrators makes a difference and whether it should be diversified. You know the Jay-Z case? Some of you may have followed. He said, wait a minute, I have to go to arbitration, but there is no diversity in the arbitrators. So so I think it's because there's not, I'm not sure how much of what I'll say is empirical based, but that's the problem. It's very, I don't know how to identify the demographics of arbitrators, and not surprisingly, even though organizations like the American Arbitration Association may have that data on they're not inclined to release it. They give little summaries. So like they're supposed to be, the last thing I saw was about 9% of AAA arbitrators are of color.
I don't know anything about the Jay-Z case, but how would they
what? They mean their rosters. Their rosters. The American Arbitration Association have rosters of arbitrators. And presumably, but I don't know how they get that information, but I'm guessing that perhaps they ask that on some initial information they collect from their arbitrators. But there certainly is no way for me, I don't know how to do it. And the only reason I can do it on this is because of the names. So, if it was in that sense, we still live in a very gendered society, but female names are typically identifiable, so, and male names are typically identifiable. Yes, sir?
I was interested in how you determine in the federal court context as to the influence. Were those decisions on jury verdicts? Were those decisions on summary judgment? I would think that like in a...
Summary judgments for the most part. What I did is I looked at every reported opinion for this decade on this topic. And as you probably know, there are not many trials that are done anymore. So most of the judicial opinions were of pretrial motions, typically summary judgments. So when I say successful, I mean that opinion held in favor of the plaintiff. So it wasn't necessarily the full resolution of the case. And people have asked, because I've talked about this empirical research in various settings, including groups of judges, who, by the way, have varied responses to this finding, is that, well, how do you know it wasn't settled, or, the next level of appeal, et cetera? But what I've also heard repeatedly is once a party gets a summary judgment, it often doesn't go on. It's settled after that point, at least in this area. At least that's what I'm told. But anyways, there's no way for me to trace it. To the extent I could trace certain cases, I did. But in this decade, I looked at all the opinions that there were, and that's how I used it.
So it is sort of apples to apples in terms of, I'm thinking about the difference between arbitration and in a court case.
There are differences.
There's a decision made in the arbitration.
There is a decision made in the arbitration. There is a decision made in the court case. It is at a trial level, typically, a district court level. So what we're talking about, and you can distinguish the cases as I suggested in certain ways, but they are resolution of disputes based on the same type of dispute. And so yeah, we could chat about it if the case distinctions explain the results, but the result remains, which is yes, gender effect, no gender effect. And so, it's meant to be exploratory research. So, anyways. Okay, anything else? Any other last questions, comments, et cetera? Thank you all. As I said, you all are the